Everyone. We have the privilege of having Judge Ronny Siegal join us today. I think it will be a great opportunity to hear from a current mediator and past judge in the family court who will, I think, provide some great insight for those considering divorce, knowing they're getting divorced, considering different options, both from a judicial perspective and from a mediation perspective. So to start, Judge Siegal, why don't you introduce yourself and what you've been up to since leaving your role as a judge?
Well, thank you, Adam, for having me. And I just want to share with your audience that we met I was a mediator in connection with the matrimonial matter where you were zealously advocating on behalf of your client. And I would note for everyone who's listening that we were able to amicably resolve that case after a lot of hard work.
With your help, thank you again.
I began really in the 70s as an attorney who practiced in all areas of the law, but I enjoyed the family area. And I was fortunate that in 2009, I was selected to be a judge in the family part. And I first served in Passaic County and thereafter in Bergen County. And my role at that point in time, until I left the bench, was to handle matrimonial matters, which included financial issues, custody issues, domestic violence issues. It was a job that meant a lot to me and which I loved. But our Constitution says that when you reach the age of 70, there's a mandatory retirement age. And so I left the bench and happily joined the firm where I currently work as a partner, heading up the dispute resolution department in family law. And I do mediation. I do arbitration, in essence, acting as a judge. And I also do consultation and representing parties in the family law area, any aspect. But I want people to understand that judges can no longer appear in court. So if there's a court proceeding, I work in conjunction with other family practitioners at my firm. So I thoroughly enjoy what I do now, and I've had the great benefit of the experience of sitting on the bench in a wonderful vicinage.
Mm-hmm. Okay, great. Okay, so in light of all that you've done, what do you like better in terms of those various processes, being a judge, a mediator? Curious to hear your thoughts about that.
Well, my quick answer is always that people listened to me when I was a judge, and I don't have that ability anymore. But what I liked being on the bench was the great number of people that I met who were so very different nationalities, different ages, different problems. And it was that breadth of people, the people that I was dealing with that brought great experience to me, knowledge to me. And I liked that very, very much. I liked the fact that I could bring finality to their issues because that was my responsibility. I had to call it for them. They evidently could not do that themselves, and I was answering the problem for them, and I liked that very much. So in terms of did I enjoy that role? Yes, but what else? There was great pressure on being a judge because what happens is you don't know the people. It's not your life, it's their lives. And in a short period of time, they have to explain to you what their issues are. How do I call that for them? My preference would always be that they could resolve it themselves, which is why I so favor mediation, if at all possible, because that affords the parties an opportunity to address their problems, knowing all that they know, and then coming to a conclusion. But on the bench, what proves to be great pressure is that you have to give them an answer, but you lack all the knowledge that they have about their lives. So you do the very best you can based upon the law and the facts. You have to follow the law, the statute, the cases, and then you have to provide an answer.
Mm-hmm. So in terms of your ability to help family moving on to get through the divorce, your role as a mediator is different than as a family judge. As a mediator, you don't have that role as in a final way, as you mentioned. So how is that in terms of without having that authority? How does that compare?
I have to always be mindful that I can't tell people what to do. The best I can say as a judge is that if you went to court and you appeared before a judge, there's a likelihood that certain things would happen based upon the set of facts that you're giving me. And that I think is what I have to do. There's a great temptation, having been on the bench for as long as I was on the bench, for just telling people what the answer is, so to speak, within a continuum. There's no right answer. If there was a right answer, I'd be out of business, but at least directing them. You can't do that as a mediator. You're trying to encourage people to find that answer themselves.
Mhm.
Yeah.
So what kind of cases should be dealt with in the court?
I find if the playing field is not level, so the most common case that comes to mind that should be in the courtroom situation is a domestic violence situation. It may not even be domestic violence as the law defines it, an inability for parties to be able to comfortably speak up for themselves. But in particular, if there is actual domestic violence, it's very hard to advocate for yourself because you are afraid to do so. That case has to have the benefit of a judge overseeing the proceedings and making sure that each party is dealt with fairly. That's something that you can't necessarily accomplish if you are in mediation. Indeed, the law says that if there is domestic violence, you should not be mediating the case. So that's one in particular. They also think when there's a lot of financial complexity to a case, there has to be discovery, meaning there has to be a complete disclosure of finances so people can make intelligent decisions. If you can accomplish that in an agreement in mediation, then that's an okay place to be. But if you can't do that, then I think you have to go through the legal process, so to speak, the more conventional way, go before a judge who will make sure that if either party needs some type of financial disclosure, they will ensure that that occurs.
Mm-hmm. So what kind of cases should definitely stay away from court in your mind?
Well, the most obvious one, if there's some type of illegality or fraud, judges have a judicial ethical responsibility to report parties that have done things that are illegal. Sometimes it's the obvious, there's unreported cash. But if you see it, there's no way of avoiding your ethical responsibility of contacting the proper authorities and reporting these people, which is not your goal. Your goal is not to do that, but faced with that issue, you have a judicial and ethical responsibility to do that. So if parties are faced with that situation, if there's some type of a fraud or wrongdoing or illegality, then they ought to go to mediation or arbitration where there may not be that duty to disclose.
Mm-hmm. So off script a bit, just a question came to mind. You mentioned that there really often isn't a black and white answer. So, in thinking about the cases that you've had to decide, do you do that in a way where you say this is definitely the way this should resolve, or are you torn until you kind of just have to come up with something as a judge?
Are you thinking in terms of as a judge?
Yeah.
Sometimes things strike you equity-wise, which is really, family judges sit in equity, a court of equity. We're in the Chancery Division. That is, although the family part, it's called a court of equity, which means what is fair, what is just. So I can't help but say to you that when you hear a set of facts, there's a knee-jerk reaction that you have to try to implement what is fair. And so if the law was simple, if it was black and white, well, then we would have no alternative. But um, there are things are on a continuum. There's a multitude of cases. There's a multitude of ways of looking at things. So I think it's never easy, but I have to say that might have been my guidepost. What would be fair?
Mhm. Okay. Makes sense. As I assume you know, and I might be off by a percentage or so, but last I checked, it's my understanding that 99% of all divorces in New Jersey get settled without a trial. Why do you think that number is so high?
I think in part, when you carefully examine the judicial process, it takes a very long time. As good as a judge may be, that judge has hundreds of cases on his calendar. So when you appear, you wait, the judge calls your case, weeks go by, you appear again. Cases can take well in excess of a year, although the policy is let's get that case completed in a year, but that does not happen. So I think people are mindful of wanting to move forward. So what can happen? You can move forward if you go outside of the system. So that's one of the reasons why a case, sometimes people put their business hat on and they say, okay, it's too costly to go to court. I'm sitting here with my counsel. He's waiting like I'm waiting. I'm being charged on an hourly basis. That's only fair. But at the end of the day, that costs a lot of money. Isn't it better to put that money in the family back in our savings or for raising our children or in our own bank account? So I think there's a pragmatic recognition that you can do things quicker. You can do things more cost effectively is if you try to resolve it. I think the other aspect to mediation, which is above all, is that you have control over the outcome of the case. When you can't resolve your case, judges frankly get upset. They've given you a lot of chances along the way to settle your case. And if you can't, then they say, well, you know what? This is how I think it should be called. And so a third party, a stranger to your life, is now going to call a case as they see fit. Is that what you really want? I don't think so. And lastly, and I hope I'm not getting too esoteric, but
Not at all.
judges can't be as creative as parties can be in the mediation process. Judges are governed by statute, by case law. And if what they want to do is different than what the law provides, they can't accomplish it. And the one that always comes to mind is a desire by maybe a mom to stay in the house with the children until such time as the children are grown. But sometimes the other party is entitled to receive payout for his 1/2 share of that house because he needs that money to move forward. Well, in mediation, you can talk about creative ways. If I were to call it as a judge, my case law and my statute tell me the house has to be put on the market for sale if the wife can't afford to pay for it at that point in time. So there's an example of the fact that judges are limited in what they can do. Mediators can often utilize some creative skills with the parties to come up with an answer that might be amenable to both sides.
Mm-hmm. So yeah, there's a lot of reasons why. So I'm curious, right, for that 1% or so that were not able to reach the resolution on their own in light of all the reasons you mentioned, in your experience, where do they usually get tripped up? What usually gets in the way? Is it legal issues? Is it emotional issues? Is it
Two striking situations come to mind. One is really anger. Parties are so angry with one another, and they very much want the court to vindicate why they're angry. And so they want the court to understand exactly what their spouse did. So anger sometimes clouds their judgment. Unfortunately, oftentimes what angers that party is not necessarily related to what a court may end up ruling, but part of it is anger. part of it is an inability to do that, to see what might be fair, to put on that business hat and say, well, let's make a decision and make any compromises. And then sometimes there are decisions that are hard. The relocation case I talk about, where there's one party who has met a significant other and wants to move to California. And I'm going to say, for the purposes of this example, it's a wife who's met another person and wants to move to California. What about that dad? He wants to see his child as frequently as he did before. How do I resolve that? Is it unfair for a wife to want to, a new wife to want to be with her husband in California? So I think sometimes there are difficult cases, custody cases, or hard cases, and sometimes it's hard to compromise. Relocation is hard to compromise, and anger gets in the way. I see that too. Yeah.
Mhm. So for that divorcing spouse who is angry with their soon-to-be ex and wants their day in court, and to tell the court how wrong the other person is and how they're a victim, what would you tell them?
Well, I think I had that situation because I often find that people think that there will be some equity in family law, and really it's disappointing and not, quote, equitable. It's really finances. So it's always a disappointment. But I used to make the parties come to court a lot because I would try to, I'm going to say, tire them out. I find that people, if they come to court again and again, having to wait before their case is called, and then quickly being dismissed because then that case is over, having to pay their counsel along the way. There's some type of enlightenment that comes after a period of time. So the passage of time might make them less angry, right? Now they want to switch to just getting it done. And also they recognize that it's on being unrewarded. It's not, they're not accomplishing what they hoped they could accomplish by going before the judge. So I think I used to make them come to court a lot. I sort of knew what was happening and I made them wait.
Mm-hmm.
That tired them out. And when they got tired enough, they were ready to settle.
Mm-hmm. And let's say if it was to a couple that has not been in court, but are considering different options how to get divorced, and they are angry and they feel they want to go to a judge, and they ask you, Judge Siegal, what do you recommend?
I've never been unhappy with the judicial process because I think there's an advantage of, if you both feel that you want to go forward with a divorce, filing the complaint, because it actually starts a process, which in reality, the legal process at every turn tries to help people settle the case. From the time they come to court in the very beginning and ask the parties, what financial information do you need? What do you want to do about custody and parenting time if they have children? The next stage is to return to an early settlement panel, which is where they meet with other attorneys who are experienced in the law, or they meet with a mediator pro bono who works and serves for several hours to try to help them get settled, have an intensive settlement conference. So there's a real benefit by going to court in one sense, because you do have a judge who wants you to resolve your case and moves you forward. But what you lack is control over the outcome. And so from my vantage point, I would say to people, if they do want to have input upon what occurs and not abandon their control over the outcome, may not be a perfect answer, but it will be closer than what a judge may do. Mm-hmm. So I do favor alternative dispute resolution if they can do it.
And you mentioned the cost before. Do you have any sense to ballpark what a cost of going to trial would be?
Yeah. Well, if I said this to you, people would say you're kidding, but it really is true. Of course, it does depend oftentimes on the complexity of assets and issues. Having said that, though, it's still time, because if you engage an attorney, and I always advise parties to have counsel helping them, they're charged on an hourly basis. So good attorneys help you prepare, they prepare. Then they're present in court. Then they review. Judges ask them to write briefs. Judges ask them to do findings of fact and conclusions of law. It costs tens of thousands of dollars. Who can afford that? Very few people can afford that. So at the end of the day, that should be a real incentive, knowing that it could be thousands of dollars, thousands of dollars.
Mm-hmm.
That could be any case because time is almost irrelevant in that context.
So you mentioned control and cost. Any other advantages to mediation compared to going to court?
Well, I do think it expedites the process. If I said to you that if you were committed to resolving your case, you can schedule mediation in rapid succession. You could have 1, 2, or 3 sessions and you can then conclude and resolve all the issues. Isn't that wonderful? That could be in weeks as opposed to months or years.
Mm-hmm.
So that ought to be something. And I must say, as one of the victims or the real victim in the or one of the victims in this process are the children. And you have to imagine that the longer this process takes, the more aware they are that their parents are fighting with one another. And not everybody has children, not everybody have children in the home. But assuming you are that family that has children, that you're either living together or you're separate and you're negotiating parenting time, your children are very much aware that you're fighting with one another, and that is harmful to them, difficult for them. So if nothing else, going through a process that's more, I'm going to say collaborative, it's not, but a process that's not brings as much friction is a better way to go.
Mm-hmm. So how would you assess whether a couple will be successful in mediation? For a couple who's thinking about different processes, what should be some of the considerations?
Well, what I would say to them is to educate themselves on their own finances. They may have come to a conclusion that they think the marriage is not going to work out and they want to separate. But they may not be knowledgeable about what their needs are in order to manage their shelter, transportation, or personal costs for themselves and their children. So they have to educate themselves. They have to also know what their finances are. So many people operate together and successfully, relying upon the other party to handle certain areas. Now they have to know those areas, and that takes some catch-up time to be able to do that. So the recommendation is before you enter into a court proceeding or before you enter into mediation or arbitration, you have to really know your financial facts and you have to get some handle on what you need. I'm a big advocate of reading a lot about the process, but I'm also an advocate about knowing your own life, because you're asking 2 people who supported one household to now figure out how they're going to support 2 separate households. And I would say to you, absent the very rich or the very poor, you really can't do that easily. It's hard. So they have to put their thinking caps on to try to figure out how to do that. And that's a reality. And that exists even if 2 people want to be fair to the other, right? It's not that they want to be unfair. Even wanting to be fair, how do they manage taking 1 or 2 incomes and now dividing it in half? Hard.
Mm-hmm.
Yeah.
Yeah, indeed. We see that all the time. So, I often hear from lawyers actually, well, if a couple was able to, mediate, then they probably wouldn't need to get divorced. They could just kind of deal with their marriage. And the fact that they're getting divorced suggests that, mediation will be of no use to them. How would you respond to that?
I would say that's not an accurate assessment. I think I have to leave it to those parties as to why they feel they want to go forward and think that they should no longer be together. I I can't measure the rightness or wrongness of that determination. But it's my hope, I call it the business hat, that they want to be fair not only to themselves but to their partner, to come up with a solution. And this is really the best way to do it through the mediation process. Fairness, yeah, I guess I'd have to say that.
So, so a couple is looking to save money, to be in control, and they're looking to go to mediation. And they, as some couples do, they see mediation as a one-stop shop to get divorced. What would you tell that couple who looking to mediate without the role of lawyers?
Well, I am not a fan. In fact, what I say is this is oftentimes your first divorce. Nowadays, it's a little bit more common, it even be your second divorce. But at the end of the day, think about that. So you are making a decision that affects the remainder of your life. It affects you, your spouse, and your children, and you haven't done it before. And you're thinking that it's wise to not get good guidance on the law, whereas you have available to you attorneys who have been there, done that for a long period of time. The law is complex. And although I'm a big advocate of being knowledgeable, you cannot become your own doctor and you can't become your own lawyer. The other aspect to it is it's very hard to advocate for yourself in that context. For me, I'm going to call it a buffer, but people representing you, and it has to be an attorney that you feel comfortable with. I mean, we should probably talk about who's the right fit when you're going forward in a matrimonial matter with an attorney, if you feel that that's what you want to do.
My next question.
Yeah, well, from my vantage point, you want somebody that you can speak with. You want somebody that you can call early, late. You want somebody who you can ask your questions to and who invites you to ask questions. And you want somebody that's respected by the judges and respected by their peers. And I think I am not an advocate of, although this is done, sometimes people engage attorneys to give them insight before the mediation. Let's talk about, you're going to be dealing with the issues of alimony, you're going to be dealing with the issues of division of assets, you'll be dealing with custody, and then they sort of prep you, and then you go in. I've not been a fan of that because I think it's always good to have somebody that you can consult with while the process is going on. And we have this great device. We call it breakout rooms or separate rooms so that you can, with the benefit of your counsel, be in one room. Your husband or wife and their counsel can be in another room, and you as a mediator can navigate back and forth. And there are times, obviously, that you can do it together. But there are times where you can be forthright. The wonderful part about mediation is that it's confidential. And what that means is it's confidential with the courts. Anything that is discussed cannot be shared in a courtroom situation. But in addition, if you express that this is what you want, it doesn't have to be shared with the other side. And so you can be forthright and you could say, this is what I really want, or this is what I might accept, but this is where my desires are. That's a real benefit. And you can go as a mediator back and forth to try to accomplish for the parties what they would like, knowing, well, I could stop there. I hope I've answered. Did I answer your question?
You did, in terms of what to look for in an attorney. Yeah, you definitely did. And just going back to court for a moment, for those uninitiated, could you talk a little about what the court process is? You spoke a lot about coming, in and out and going for meetings and, waiting and submitting briefs. But could you talk a little about, for the layman, what the court process is like?
Certainly. So to begin the process, one of the parties filed what's called a verified complaint for divorce. And that complaint for divorce, which sets forth the grounds for why you're seeking a separation, why you're seeking a divorce, and what it is that you're asking for. You're asking for alimony? Are you asking for division of the assets? Are you asking for custody of your children or visitation with your children? That document is the step number one. And that document must be served on the other side, on the other spouse. And then that spouse has an obligation to answer. It could be a simple answer, it could be a more complicated counterclaim, but there's an answer. And when those two items happen, an answer and a complaint, when they're joined, then the court fixes a date for you to first appear. And your first appearance, called a case management conference, is an opportunity for the court to meet with you. And that's wonderful for the judge. He has a chance now to meet the two of you and to find out what kind of a case he has. Is it a simple case, meaning are there any children or not? Are the assets complex or not? What are the issues? That's what the judge is going to ask. And you have a chance to meet your judge, and the judge has a chance to meet you. And in New Jersey, it's one judge handles your case. So that was a development in the law, but it's a real benefit because now you know who your judge is and the judge knows who you are. But after that's done, after you indicate to the judge about your case, they give what's called a discovery schedule. And that means an opportunity for both sides to find out whatever information they think they need financially to understand what the assets are, what they're worth, and think about how they should be divided. In addition, the first into all courts are the children. So if the parties have resolved what's going to happen to the children, they're home free. But if they haven't, there's an affording of free mediation at the courthouse where you can sit with a mediator and talk about how you envision your custody and parenting time. So that's the next stage. Certain period of time elapses, you come back to court. Has the parties received the requested financial information they need? Have they resolved their custody and parenting time issues? If they have, that's wonderful. Now you're going to go to an early settlement panel where you meet with hopefully three attorneys who are experienced in matrimonial law. You'll ask them your questions, and they will try to tell you what will happen if you went to trial to answer your questions. But if you have not gotten your discovery, if you haven't resolved your custody and parenting time issues, maybe we're talking about motion practice, right? Maybe we're talking about engaging experts to determine should a child be with both parents, should be one parent, is there drug or alcohol issues? It becomes a little bit more complicated. Is domestic violence an issue that's going to affect not only the other party, but how you're going to rear the children? So stage number two, after that early settlement panel, if all goes well, if the parties have resolved their case, they can get a divorce that very day. But if they haven't been able to resolve their case, then the next stage is what we call mediation. Again, the state says first 2 hours, you mediate with an authorized mediator, and you can present your issues. Again, there'll be some further discussion. If you can't resolve it at mediation, if that happens, they're going to give you a trial date. And before that trial date, we try to do what we call intensive settlement conferences. We bring the parties and their attorneys, if they have counsel, to court, and we make them stay there. Sometimes we make them stay there more than a day, consecutive days. Again, you and I talked a little bit, how do we get people to settle a case? Well, if you know that you have to be at your job and your job feels you've been taking off too much time and some judge tells you you're not allowed to leave and you have to stay there and you have to come back the next day until you get it done. Sometimes you try to get it done. So that last stage is that intensive settlement conference, and then they give you a trial date. And so you're ready for trial. A lot of work in preparing for trial, and it never comes as quickly as people would like. It could go months and years. And with the pandemic, as you know, people have not been appearing in the courtroom situation. They appear by Zoom, right, if they appear at all. And it takes months, years, and that's unfortunate.
Okay, that's that really spells it out. Thank you for doing that. shifting away from the court process. I know you're a little familiar with the collaborative divorce process. Can you talk? What's your take on that approach?
Well, I think as I get older, I like it better. And I'll tell you what I like about it. To the degree that I can espouse that approach, people come to the table with a view that they both want to resolve their case. And that idea that they're committed to resolving their case is something that I like. And they are armed with, I call it armed with, maybe that's the wrong, they have available to them forensic accountants in case there are financial issues that have to be done. They have mental health professionals that they can call upon to help them answer and guide them. And they have attorneys. So they get through this process, I would say, knowing that they both want to resolve their case. What's the downside? There are some downsides. Not everybody, maybe people think that they are on the same level, sometimes they're not. And then I think what I always hear is that there's some lost time because the attorneys that you're retaining for the collaborative process are committed not to be involved in litigation. And so you have to sort of begin again. So as long as it might take going through those steps, you still have to begin again. And it could make it a little bit longer. So from my vantage point, I think that's a negative. That part of it is a negative if it turns out that you can't continue and resolve your case through the collaborative process. Mm-hmm. I don't know if it's fair of me to ask that of you, but you are pretty renowned in that area. Is that a negative to you too, or that's just the nature of the work?
Yeah, it's certainly, I guess it's a negative that comes with an opportunity. So the negative is a reason why there's an ethical mandate to make an assessment that we just don't accept any case. There has to be a certain level of scrutiny as opposed to going to litigation to say, does this family have enough money? Do they have the psychological wherewithal? Do they have kids old enough that maybe won't be impacted or whatever it might be? As opposed to assessing whether litigation is the right process, that where there is no ethical obligation, at least not on the books. Collaborative, there's an ethical opinion which says that we need to be careful and assess that the clients have the capacity, the interest, the wherewithal to resolve things collaboratively. And if one of the attorneys or other professionals feel that that's not the case, then we should not take on that case collaboratively. And I've had that. I've had a number of cases, been doing this over 20 years, where either myself, and I'm specifically thinking now of two other attorneys that, where I thought it would be good from speaking to my client or potential client, the other attorney says, Adam, I can't say more. I can't breach client, attorney-client privilege. But from what I see, this is not appropriate for collaborative. So, so there is some screening to deal with that concern.
That's a good one. And I had one other question, and this will be my only other question. One of the techniques that I have found helpful in mediation is being able to go from, I'm going to call it room to room, and speak with parties separately and find out what they think and what are their concerns and go back. And I'm not sure, because I don't know enough about it, whether that exists in the collaborative process. Do you have that in the collaborative process?
It does. I mean, it's in the sense of where you meet with your lawyer separately. It does. Yeah, there's the collaborative process has a lot of flexibility. There's no one size fits all in terms of the ideal way of doing it. There's kind of a textbook when I teach this. Generally the most of the action, the resolution happens in joint meetings. But before the joint meetings and after the joint meetings, there's preparation, there's debriefing. So we're really prepping for those joint meetings to have all the productive work. But if there's a bump of the road, yeah, there is a place, where there'll be separate work. And especially, as opposed to mediation, where you're primarily relying on that mediator, the presence of that mediator, in collaborative, because there's a lot of that separate time preparing and debriefing with your attorney, there is a lot of separate work as well.
That's good to know for me. Yeah.
So you've been doing this kind of work for a very long time, and I'm just curious to hear, like, on a personal level, if you don't mind sharing, how do you deal with being surrounded with the conflict, these kind of often negative dynamics that divorcing couples have on a day-to-day basis?
Two things are my takeaways. As a judge in particular, having to make a decision, there was a real weight of having to make a decision that was of such great consequence that would affect people's lives for the remainder, and I really wanted to get it right. And so that was a great weight that was always on my shoulders. Was I making the right decision for them? In other situations, it's, have I thought of enough ideas? So in mediation, where you're trying to accomplish the desires of two people that are oftentimes very different, have I thought about every possible way? If we can't do it this way, is there another way that we could do it, that I could accomplish what the two people want? I think that was those are the greatest pressures I have felt in this area. Clearly, as a judge, as a mediator, as an arbitrator, there's a window that's open, and I'll see people who are at their unhappiest, right? They were married and now they're separated from one another and they are unhappy. And you unfortunately can feel how sad, frightened, right? They're frightened because they don't know what the future holds. They know what they have, but now they're treading they're entering into a new life. I feel that for them. So those are pressures. But I think for me, the pressure is, what can I do in my role, either as a judge or as a mediator, to get them the best possible result.
Mm-hmm. So what do you find most rewarding in your working with divorcing couples?
Well, frankly, it's just that I could bring it to an end for them in a way that they feel optimistic about the future. Sometimes you can't, but for the most part, if you can do that, very heartening, very heartening.
Mm-hmm. I'm reminded of what they say the difference between criminal law and family law, right? Where criminal law, you're dealing with, I will say, not so good people looking their best or at their best, where family law is good people at their worst.
Yeah, that's true. That's true.
And it sounds like you share my, my goal as well, to help these good people get through this the best way possible.
Exactly. Yeah, I feel that way. Yeah.
So what would be your parting message for a couple who's starting the divorce process, contemplating different ways to go about doing that? What would be your message to them before we finish?
Assuming, I think I would like both of the parties to feel as comfortable or as confident as they can that they've made the right decision, because it is of such great consequence. That they educate themselves and learn as much as they can learn about the process, and about their finances and what they want for themselves. And then be fair to the other party as well as being fair to themselves. And this was somebody that they loved, that is the other parent to their children. And so to be respectful and to try to be fair. And then I guess it would be those two things: respectful and fair, and feel knowledgeable. about what they're doing.
Mhm.
I guess that would be it.
Yeah, that sounds like some good messages. Yeah, yeah. Thank you for sharing that. So, for those that are interested in finding out more about you, your services, your role as a mediator arbitrator, how would someone contact you?
My name again is Ronny Siegal. I am at the Pashman, Stein, Walder, Hayden Law Firm. We're located at 200 Main Street in Court Plaza South in Hackensack, New Jersey. And if they just look us up, 201-488-8200, they can speak with me. And I would be happy to speak with everybody just to talk it out with them.
Great. Okay. All right. Thank you so much, Judge Siegel, for sharing your expertise. A lot of important pearls of wisdom that people going through this would definitely benefit much from. So thank you so much for your
Everybody,
time.
wish you a happy new year. And thank you for this opportunity to speak with you.
Thank you.